Thank you, as always, for coming along this afternoon. As you probably know, we try and rotate through our sections once every Friday, once a month. One Friday each month to cover various topics. So this is my slot for this year. I think maybe there might be another slot, but it's we think that. Well, we hope people get some value out of them. It seems as though not many people run these kind of events as regularly or as often as we all used to back in the 2010s to earlier 2000s. So we nonetheless we still try and like to do them as often as we can. The topics today that I've chosen, they're interesting. Insofar as some of the fact scenarios are interesting. I think they're more interesting, though, in terms of the issues and the complications that are arising out of the cases that we're going to go through. I've chosen two cases, one dealing with redundancy and one dealing with workplace policies and in particular drug and alcohol testing. I'm assuming you've come along because there's some interest in both or at least one of the topics. So please make sure that if you do have any questions, you stick up your hand and ask, and we'll do our best to answer them. And like always, even if the question's got nothing to do with what we're talking about, I'm still happy to try and answer it as best I can. So welcome, coming in. All good? Yep. Around the ground, I like to also do before we start though a bit of around the grounds, and this is sort of the most recent. So what happens is that we get fed, like you all do in your own industries, you get fed a bunch of information almost daily, and you have every opportunity you can. You have a quick flick through it. We try and keep an eye on things that we think are either interesting, important, or are likely to impact you individually in your businesses in the near future. And so the whole idea of around the grounds is to, no, you're right, is to go through and bring some of this stuff to your attention. So if you've heard of these, let me know. But the first one, the first round the ground is the 21-day time limit. Does everyone know? So if you lose your job, you've got 21 days to bring a claim in the Fair Work Commission. That's either for unfair dismissal or breaches of the general protection provisions of the Fair Work Act. So that 21-day is a statutory time limit. There's a discretion that the Commission has to say if you don't put your application in within that 21 days, well then we can extend the time frame if we want to allow you extra time to file your claim because of whatever reason. Two matters arose recently. The 21 days ends at midnight on the day that your 21 days expires. So it's not a 5 o'clock in the afternoon deadline. It's a midnight deadline. So you have until midnight on the 21st day to file your claim. There's two matters recently. Someone filed their claim 16 seconds late. So 12 a.m. and 16 seconds, and someone else 4 seconds late. Now, historically, I would have said, oh, there's no way in the world you'd raise a jurisdictional objection. The Commission is going to allow them 16 seconds. So what? They don't care. Well, these two cases, the Commission rejected both applications because they were out of time, despite only being 16 seconds and 4 seconds late. So if you're on the receiving end of an application and it's not, and you see the receipt of being 12:01 and 12 seconds, for example, there may be a jurisdictional objection that you can raise which says that the Commission can't hear that application because it's been filed out of time. And what the Commission said is that it's not you lodging it. So you don't lodge it at 11:59 thinking that's sufficient, that's within your 21 days. it's when the Commission issues the receipt, the electronic receipt, to say when it receives it. So long as you receive that receipt before the end of the midnight on the 21st day, then you're sweet with your application, or you've got to defend the application, whichever it may be. So I thought that was pretty interesting, and part of it, I think, is also because the Commission is dealing with a significantly increased number of claims because employees are using AI to fill out their applications and they are being bombarded. So what used to take a process of you get the application, you'd put in your employer response and you'd have the conciliation, might take 2 or 3 weeks. It's now taking up to 2 months because they're just so inundated with applications at the moment. AI. This is always an interesting topic. The ACTU have been pretty active in this space. What they are saying, if you have a business restructure where you are restructuring because of some benefit that you're going to gain from implementing AI in your business, if you don't follow the consultation obligations that are set out in an applicable award or policy in your workplace, they're going to come looking for you. Now that's the ACTU, so that's then obviously every union underneath the ACTU. So that's a really important position. The second one with the ACTU, there's a parliamentary inquiry at the moment into the national employment standards. So the 10 national employment standards, 38 hours a week, 4 weeks annual leave, parental leave, all the rest. They have made a submission to the parliamentary inquiry, and bearing in mind we have a Labor government, to increase annual leave for all employees from 4 weeks to 5 weeks. So if it's a pretty easy vote win if you're looking for mass votes to increase the entitlement from 4 weeks to 5 weeks. I would suspect we've had 4 weeks since the 1970s. I don't see it changing, but who knows in this climate? So it's a bit of a crazy time in more ways than one. And finally, the last around the ground is sham contracting has become a spotlight for both the Fair Work Ombudsman and the Tax Office. So they have joined forces to try and track down anyone that's involved in sham contracting. Hand up if you know what sham contracting is. It's effectively where you say to someone, I'm going to employ you as a contractor and not as an employee. And you do that in circumstances where it's more likely than not, or you should reasonably know that it's more likely than not that the person's an employee and not a contractor. And in those circumstances, you can be fined upwards of between $20,000 and $100,000 for each sham contract. So it's a focus now, or a spotlight that the ATO and the Fair Work Ombudsman have teamed up on. So that's the around the grounds. Any questions coming from that? No, all good. People at the door, come on in. All right. I always forget this slide, and I should always remember it, but this is the disclaimer side. So this is obviously what I'm telling you today is for information only and not advice. I should probably remember that. Anyway, first case. Anyone heard of this case? High Court decision. No? Okay. So this is our redundancy case, and it's. I'll get to obviously why it's interesting, but a little bit of the background on it. So this is a company, Helensburgh Coal, that operates a coal mine called the Metropolitan Coal Mine. They have in their workforce a combination of employees and contractors, quite understandably. So they've got some employees that they employ directly to do the work at the mine, and they use labour hire companies to outsource and some of their labour and get work in or get employees in through their labour hire arrangements. Pretty, nothing significant or interesting about that. In 2020, 2021, COVID. This is how long this matter's been going on for. COVID hit, and everyone went, okay, well, hold on, I'm going to have to make a look at my workforce because there's been a reduction in productivity or demand or whatever it might be, and so this is going to impact on our workforce. So they make 47 employees within the business redundant. Again, not anything too substantial about that or too interesting about that. And the other labour hire companies, they make some of those employees' positions that had been outsourced no longer. Of those 47 employees, 22 bring a claim in the Fair Work Commission for unfair dismissal. Any guess as to what the ground might be? Sham redundancy. The redundancy wasn't genuine. So 22 employees. So it's not a class action. We don't have class actions like that in the Fair Work Commission, but it's the closest thing that we'll probably get. Where 22 employees on behalf of brought by the trade union asked the Commission to say that the dismissal for their dismissal was unfair on the basis that the redundancy was not genuine. The reason we're only talking about it now is because that happened in 2021. The Fair Work Commission, and I'll get to the end now. So the Fair Work Commission found that those 22 employees had been unfairly dismissed because their redundancies were not genuine. Bearing in mind this is during the COVID period where the roles do actually evaporate, but the Commission found in these circumstances that the decision to dismiss them was unfair. They appeal this, goes to the Federal Court. Federal Court agree with the Fair Work Commission and say, actually, no, your appeal's dismissed. The Commission was right. The 22 employees were unfairly dismissed because the decision to dismiss them was not a genuine redundancy. Goes to the High Court. High Court only in the last 6 months, from memory, late last year, agreed with both the Fair Work Commission and the Federal Court to say that these 22 employees were unfairly dismissed because of the fact that what the decision to dismiss them was not a genuine redundancy. Now, when you get to the High Court, it's a pretty difficult and expensive process, as you might imagine. But the High Court sits and they have 7 members sitting on the bench of the High Court, and they all can issue an individual decision or they can issue a collective decision. Some people, three judges got together and said this is the reason why it was unfair. A couple of others agreed, but for separate reasons. But the majority, or the most important part of the decision, is the 3 judges that agreed together that this dismissal was unfair. Now, you might be asking, what is a genuine redundancy? Because that's the key question in this. What is a genuine redundancy? Section 389 of the Fair Work Act, if you're ever bored and you can't get to sleep at night, pick up the Fair Work Act. Or it's good as a doorstop. It's pretty, actually, just as a segue. In 1988, this is showing my age, I wasn't practicing, I was still in school. But the industrial relations legislation was like 90 pages long. It was like, that's all we had governing our employment space. We now have 15 pages of thousands of pages of legislation just telling us what a casual employee is. So we've got this huge increase in information that we now have to deal with. And it feels the whole closing the loophole arrangements that we've been dealing with over the last few years feels a bit like whack-a-mole. You know, an issue pops up, they legislate to whack it down. Another issue pops up, they legislate to whack it down. This is one of those cases where there might be a bit of legislation that comes after this because of the High Court's finding in this case. So, but in any event, that's a bit of a side issue. Any questions so far? No, pretty straightforward. So Section 389 of the Fair Work Act says a person's dismissal was a case of genuine redundancy if two issues are met. A, the employer's job is no longer required to be performed by anyone because of operational requirements of the employer's business, and the employer has complied with their modern award obligations, so the whole process of consultation. This is that, getting back to that ACTU issue that I mentioned earlier. So that's ground one. Ground two is a person's dismissal was not a case of genuine redundancy if it would have been reasonable in all the circumstances for the person to be redeployed within either the employer's enterprise or the enterprise of an associated entity of the employer. And it's this second part in this case that was where the argument was won or lost. So this is all about whether a person's dismissal is there a penalty for a phone going off in a shout the bar? Yeah, shout the bar. It's a good bar to shout. It's full paid for. So a person's dismissal was not a case of genuine redundancy if it would have been reasonable in all the circumstances for the person to be employed within the business. So you might remember that what I was saying before was that you had 22 employees and you had some contracted labour, some labour hire contracted labour. It's not uncommon for a redundancy situation for people to retain different parts of their workforce, despite the fact that they're not all employees. So it's not an uncommon scenario to say, well, we've got 47 employees. In this case, we're getting 22, but we need the contracted labour for other, tasks. So it's important that we keep some of them, not all of them. So we need to, in that case, it's all okay because there's no longer jobs. These 22 jobs or 47 jobs are no longer required, despite the fact that we've got this labour hire stuff happening over here. That's not an uncommon, has often been the case. Second thing is, and an important part of this decision, is that it's also not always, it has always been thought that you don't, if you make a person's position redundant, and when you go to the redeployment issue, so this is all about would have been reasonable in all the circumstances for the person to be redeployed. It would have been, that does not mean you have to make it a job for the individual. So redeployment is redeployment into another role that's vacant, not redeployment into a role that's not yet in existence, but could be if the person had certain skills or requirements. So that's the historical perspective. As you might understand, where I'm getting to here with this is that this decision has changed that, and the High Court has been very express about that. So the High Court has really analysed, and I'll get to it here, they've really analysed almost every word in this particular section to give us some guidance now on what redeployment or what is reasonable in the circumstances for the person to be redeployed, to give us meaning about that. Because it's a High Court decision, every other court below the High Court has to consider it. And we don't appeal to the Privy Council over in London anymore. We finished that in the early 90s. So this is the unless another person brings a claim to try and overturn this decision, this is now our obligations when it comes to considering redundancy. And again, linking this back to the ACTU's focus on redundancy, particularly in a world of advanced AI and people losing their jobs potentially, it's a real and genuine and proper consideration that we all need to consider. So first things first, it says a person's dismissal was a case of genuine redundancy, and the court was asked to look at what is the employer's enterprise in the context of this particular section. So what the court did, quite understandably, they go to the index or the definition section in the Act. Lo and behold, enterprise is defined, and it says an employer's enterprise is its business, activity, project, or undertaking. So if you, depending on where your business is at, depending on what projects it's got on, what activities it's engaged in or is going to engage in, whether its business undertakings are changing or not, those are matters within the scope of the Fair Work Commission to consider as part of this redundancy proposition. The second thing that they focused on is, and this is whether it would have been reasonable in all of the circumstances for the person to be redeployed. So and again, this is the point that I mentioned before, redeployment does not require there to be a vacant position. So the court said this, there does not require there to be a vacant position or prohibit a change to how the employer uses its workforce to operate its enterprise. The term contemplates some reorganisation or rearrangement. So redeployment now, so what the court's saying is obviously that when you're looking at redeployment, and you've got to look at redeployment because the Act tells you you have to when you're making someone's position redundant, it's not just about is there a position available or not, it's whether some reorganisation or rearrangement can be made within any part of your business that person then might be able to fulfil before you make their position redundant. The third point is whether redeployment would have been reasonable. Now, what Helensburgh Cole said in this case is that, well, that doesn't allow the Commission to run hypotheticals. It doesn't say that, well, you know, hypothetically, if this happened, would that position still be available? But the High Court has said because it uses the words would have been reasonable, would have been does direct the Commission to consider the hypothetical situation. So what at the time of dismissal could have been done to reasonably redeploy that person within the enterprise. So again, another layer of consideration and analysing the circumstances of your business to determine whether or not redundancy is or redeployment is an option or a genuine option, and if it is, then that's the expectation that following this case is that you will offer that person that role, and if they accept it, great. If they don't, then their position is made redundant. Reasonableness, well, that's an objective question and must be considered in the context of the employer's business. And what does all the circumstances mean? Well, all the circumstances is a very broad language and a very broad term, and it means all of the circumstances. So there's almost this linear consideration, because you've got to look at and there's a whole range of, but I've picked out some of the important ones. You've got to look at, for example, whether your contractors, so your labour hire companies in this case, whether your contracts with them employ workers on a fixed term, long commitment basis, or is it just a as needs basis? If it's an as needs basis contract, it would suggest then that they're not necessary, so you can terminate that contract with the view to keeping your employees in employment, doing work that these employees would ordinarily do. Versus a long-term commitment. So, you know, in terms of lineage, you've got to look at the contracts that you have beyond your employment contracts, but your external contractors to see whether there's something that can be done with them that would allow you to keep your employee. Other things that you need to think of: do you have someone going on parental leave? Do you have someone going on, someone having a contract expire? Is there a position that's vacant? Obviously, is there a position being performed by a contractor waiting for an employee to be hired? So this is the direct language of the High Court about things that we need to consider now when we're making a position redundant. I know that probably is a lot of information on a Friday afternoon, but there are some lessons, and I'll let you go through them. Any questions coming out of that? Is anyone dealing with a situation like that at the moment, or has dealt with and wondered what the obligations are or were?
I used to work at that one, so I know this is the makeup of that one.
Oh, right. Oh, there you go. I should get you up here.
So I know that other contractors work down there doing a secondary sport down there. It is quite specialist type of skill set.
Yes.
Using that contractor's equipment.
Yes.
To do that.
Yes.
Would it be reasonable, because like if they've got that contract there, we're using our own gear.
Yes.
For them to then go over and use that gear, it would be an expectation on Helensburgh to actually then train them up to use that before they would be made redundant.
Yes.
But also, because Helensburgh...
So that was wet hire. So you were hiring the driver as well as the machine?
Yeah. So
yeah. I think, yeah, okay. Yep.
You know, all the contracts and then all specialist
yep.
type of support work for the mine.
Yes.
Slightly different skill set. They'd usually be trained up to do it.
Yep.
Different equipment, that type of stuff. It would be the expectation that if they were contracted to do that with their own gear,
yes.
that we would be putting those people on.
Yes.
But that's how that contract is for. It's not a dry, it's a dry hire.
So I think the relevant consideration there is that in the context of this decision is that if you've got a company providing services that is both the machine and the driver,
yeah.
That's different to just getting the driver.
Yeah. You
might not have anyone yet trained to operate that machine, but is there a reasonable expectation that person could, is two weeks away from getting their ticket? Yeah. Then that's a circumstance that you would need to consider to determine whether you should be making that position redundant, or whether it's reasonable to wait 2 weeks, get rid of that driver who's on a contracted basis to keep your employees employed. Yeah. So the analysis that goes into now then determining whether a position redundant is quite significant. It's not uncommon for people to come and present two scenarios. One is that the employee is underperforming, but at the same time, we've had a look at their job and we don't actually need their job anymore. Our advice has always been that if the real reason is the underperformance, and whilst the redundancy circumstance might be the easy out because it's more palatable for the employee to be told they're redundant rather than losing their job, it's always been that if that's the genuine reason being the performance reason, then you should focus on that and go through the process to make that decision, because that's the real and legitimate reason. This only adds weight to that argument, because otherwise, if you make their position redundant and you haven't done that full and proper analysis of individual skills, where they are at in terms of their life, education and all the rest, having regard to both your immediate business and any associated entity that you are engaged with, then you're going to fall on the redundancy argument. So you're better off managing the performance or the misconduct.
Sammy, what did they, when you get into that, like what was the High Court's reason?
Well, all of those 5 things that I went through. So they said effectively that Helensburgh had done none of that, and the commission and So they said the argument was that the Commission didn't have the right to go beyond and look into the business to tell it how to operate its business by restructuring the business to allow it to determine whether someone should be made redundant or not. The High Court has said, well, actually, the Commission does have the right to do that because of our analysis of all of these terms that are built into Section 389 of the Fair Work Act.
So the fact that that person may not have the skill set to fill another role in the business
at that moment in time, yeah.
Is that not good enough?
Say that again?
If the person that you're making redundant...
Yes. Well, it's the position you're making redundant, not the person.
Position.
Yeah.
Right. But the crux is that you've got to redeploy that person.
Yes.
So if the person doesn't have a skill set that can be utilised in any other part of your business.
If there's a vacant position, that it would be it would be reasonable to expect that you could train that person fairly easily to fit into that role, then that would be a consideration you would need to consider.
Say, for example, we had someone who designs hydraulic, like plumbing,
yep,
water, sewage, and that sort of stuff.
Yep.
But we don't have any work in that area.
Yes.
And we have a vacant position in the structural
yes.
engineering part of our business.
Yes.
It's not reasonable. That person wouldn't have the skill set to train them to do the other role, but it is a vacant role in our business.
Well, and good analysis and good question. I guess the vacant role, is it a senior job? Is it a junior job? Is it, but these are well, yeah. Is this all hypothetical? Yeah. Only joking, John. Because it would depend. I mean, from an outsider's perspective looking in, I don't know what the difference in training is between a hydraulic engineer versus a structural engineer. If it's 3 university subjects, that is the distinguishing feature between being a hydraulic engineer and a structural engineer, then maybe it's not appropriate for that person to be able to go into that role. It would the analysis would be, can they do it, firstly? And if not, how long will it get us to train that person up? Secondly, thirdly, is it reasonable? I think it would be reasonable to ask, should that person be paid the same rate in circumstances where they don't have the skills necessary to be able to do the job immediately? So there's a whole range of things, I guess, that are coming into the analysis. And if the answers to that are no, it's not reasonable because it takes, as I said, 3 university subjects and it's, we're talking 18 months or whatever it might be, then no, go out and find yourself well, absolutely. You can offer them and they say no, well, their position's redundant and out they go. Yeah. That's pretty big ask on any organisation. This is weighty. Absolutely.
Anyone could feel like it could be sweeping the floor.
It's the bigger the organisation, the more difficult it's going to be to argue against this. And if you're a business with a number of associated entities, so you've got a construction business that has a hire machinery business and a drafting business, and they're all associated with together by definition as to what an associated entity is pursuant to the Corps Act. Then the expectation is that you're not looking just in that entity, but you're looking across all of the entities to determine whether or not that person can fit into a role somewhere down the chain. Yeah. Yeah. You kind of get the well, maybe that's wrong because it was 2018, but to get to the federal court and then to get to here takes a long time. And, maybe the High Court is saying, well, actually, we know that AI is coming and we want people to not necessarily just be made redundant without proper consideration. So it's a bit of a policy decision as well. But yeah, it's for any organisation, what has always historically been seen as a pretty simple process has suddenly become a bit more complicated.
We have clients who are implementing robotics.
Yeah.
And that would definitely make people's positions redundant.
Yes.
But then if they do other things, like one of these firms is a multinational.
Well, if they got other, you might lose your job to the robot, but you've got these skills over here that can be transferred somewhere else within the business. All right. Any more questions coming from that? All right. Any questions coming from our lessons?
Yeah.
Yes.
May not be directly questions. But is there still a situation about a minimum number of employees for redundancy to be applicable?
There is in terms of severance pay. So 15 or fewer employees, you don't have to pay severance. So redundancy pay is made up of notice and severance. So small business employers are exempted from the severance pay. There is an additional 6-month protection to an unfair dismissal claim between a small business and a not small business by definition, and that's 6 months and 12 months from the commencement of their employment. But otherwise, outside of that, this is going to apply. You're thinking back in the old legislation, I think.
Yeah.
Yeah. Yeah. No, the question is whether it's a genuine redundancy or not, and that's the question we have. So long as you get through the gate of your minimum employment period. No other questions? All right. Next case. We're going time. Is Craig Hancock and Sydney International Containers. Anyone heard of this case? Probably not. So this is again another recent decision, this time out of the Fair Work Commission. This is our drug and alcohol policy decision. So Mr. Craig Hancock, member of the MUA, was seemed to be a fairly long-standing employee. This was it Good Friday? Easter Sunday, 31 March 2024, Easter Sunday. He's starting work at 10 o'clock at night. His neighbour earlier in the evening invites him over for a glass of wine before he goes to work. He goes over, he has one glass of wine, and heads off to work. He's a crane operator. He gets to work. He's at work for 40, 45 minutes. There's an accident with loading one of the shipping containers onto a ship, is what I believe, I think. And he's immediately asked to submit to a drug and alcohol test. Mr. Hancock is of the understanding at that moment in time that so long as you had a blood alcohol reading of under 0.02, sorry. Yeah, 0.2. You can't drive, but you can operate a crane. Sorry about that. 0.02. He thinks that I've only had one glass of wine. I'm right to operate this crane. He blows, and I think initially he blows 0.001 0.021, so he's slightly over. Half an hour later, they do another test, and he blows 0.017. He thinks then that he's under the blood and alcohol level that is allowed within the organisation to operate a crane safely. He's immediately sent home. He goes home thinking, well, I haven't done anything wrong, but I'll deal with whatever comes next. They go through the usual process. Allegations are put to him to say that a number of things. One is the policy. The company says that the policy was 0.00% alcohol, and because you're over and above that percentage of the reading, you're in breach of the policy and therefore may lose your job. He responds and says, honestly, I believed it was 0.02. I didn't think I'd done anything wrong. Despite that, the company, obviously, if we're finding ourselves in the Fair Work Commission, have decided to terminate his employment, and he brings then a claim for unfair dismissal. As part of the decision-making process, he had actually also been warned on 2 previous occasions about breaches of policy whilst he's been at work. The commission go through the process. So when you have an unfair dismissal claim, so he brings a claim for unfair dismissal asking for his job back. The commission really considers 2. So Section 387 of the Fair Work Act deals with 5 items that you would consider. It's a bit of your checklist, if you like, for working out whether you've got you're in a position to make a decision to terminate someone's employment. 387.1 deals with a valid reason. That means that in all of the circumstances, is it fair for us to make the decision to dismiss this person? And that's where probably 99% of cases dealing with unfair dismissal win or lose. The next 4 items all deal with procedural issues, opportunity to respond. If it's performance, have they been given an opportunity to improve their performance? Notice of the reason for the dismissal. 5 is any other circumstance that the commission might take into consideration. So in this particular case, Mr. Hancock runs the argument that he effectively said to the employer during the process, I thought the policy was 0.02, and therefore I didn't think that I had done anything wrong. The commission said on ground 1, valid reason, yes, there was a valid reason to terminate Mr. Hancock's employment. B then through to D, yes, they complied with all of the policies, etc., and or the process, in terms of giving an opportunity to respond, natural justice, all the rest, and so they were successful in that part. Where they went down is in the final part, any other circumstances that the commission can take into consideration. And this is where the commission focused or really honed in on whether or not the policy that had been changed, because it was 0.02 and changed to 0.00, whether that had been sufficiently communicated to all of the staff, so much so that Mr. Hancock should have known that by having 1 glass of wine, he was going to be in breach of the policy. Mr. Hancock ends up winning and is reinstated with compensation and is now back at work at the Sydney International Containers Terminals. What the commission, and again, this is important because it's the most recent commentary we have about policies, and we all know with policies, it's not just about telling people, it's about getting them to understand. So what Deputy President Wright went through was a bit of a 5 or 6 step, well, not step, but ticked off 5 or 6 items and made comments about them as to whether or not it's appropriate or reasonable or sufficient to do these things in order to train people about their policies. So if you've got a workplace where you've got policies in place and you're changing them, you need to, some of these things are going to be important to you because it's not just a matter of ticking a box and saying the policy's changed. So the first one was text messages and emails are not appropriate. So what happens, because, I mean, as a solicitor, if I send an email, I'm going to readily receive that email because I'm sitting at my desk. That's what I do. A crane operator may not necessarily get their emails directly whilst they're at work. The employer ran the argument to say, yes, that might be right, but they do have downtime. So in between shifts or in between breaks or in between one part of the job being completed and waiting for the next part, there's downtime during which they can read those emails. The Commission said text messages and emails to employees' personal addresses was not an appropriate way to communicate a change such as this. So sending an email to your staff, to their personal email address, they may not open it, despite the fact that that's the way that you usually communicate with them. That may not be sufficient. Secondly, there is no requirement for employees to check work emails from their personal email account. So I don't know really how the Commission understood this, but anyway. So basically what they're saying is that the Commission highlighted that if a person receives a work-related email on a personal email account, the possibility is that the employer will not open that email and will then leave it unread. So sending a work email to a personal email address is not sufficient because the employee may not read it. Toolbox meetings, not effective. So we know that toolbox meetings are the way that we talk about policies. They found that the routine of a daily toolbox meeting before every shift was not reasonable, that it meant that it was not reasonable to expect employees to remember every issue that was discussed. Toolbox meetings are useful, but they're not as good as a dedicated training session, effectively is what they're saying. So you can talk about it. Don't expect your staff to remember it because it's as they walk out the door. They're not as good as a dedicated training session. Posters and flyers are not effective. So putting up a poster that says blood alcohol levels at work are changing, it's no longer 0.02, it's going to 0.00. Just having that poster plastered around the lunchroom, that's not sufficient either. Because that while they might be a useful source of information, the company in this case was not able to prove the extent to which employees read those materials. So they couldn't go along to court and put their hand on their heart and say, yes, every person saw that poster, because they just can't. Sorry, no, yes. Yep.
And you ended up having a policy with a sign-on sheet and around everyone to actually sign.
Yep. That it sounds simple and it sounds like that would be sufficient. I'm not sure that it actually is, because these guys had toolbox meetings, they had posters, they had emails, they had all of those usual things. This guy, Mr. Hancock, who, by the way, brought in 5 of his mates who all said, "Oh, we didn't see the policy." They didn't see the policy either. So the Commission said, well, none of that was obviously sufficient enough to educate the people, to warn them or let them know that there had been that change of policy. So there isn't in this case the signed acknowledgement that what you're talking about, Dave. So it might be that having the training, the dedicated training session, having the person sign off acknowledging it is sufficient. It's going to be better by the sounds of it than not having it, because it didn't seem as though that was a consideration in this case. Yes. Again, anyone, yeah, you can. We all sign it. and I guess that's the point. That's the point the commission is making, is that everyone has these tick and flick systems where they say there's a policy, there's toolbox meeting, they should know. Effectively saying, well, that's no longer enough, particularly with a really important safety issue. It might be okay for less important policies like a leave policy or something, but not a safety policy. Well, well, no, that's what I'm saying. In this case, they did not have the signing. Yeah. Well, I can't guarantee that that's going to be enough, but it's better than not. It's better than not having it. We've all got to be reasonable and sensible with it, and you would think signing off with an acknowledgement is sufficient, and that might be right. I can see circumstances where a person might say, "Well, English is my second language," so you've got automatically a more difficult scenario.
So how would that, they said they didn't run a training session?
Yes.
That wouldn't help that situation.
Well, it would have in this case, because they say here that the commission stated that employees would be more likely to retain information about policy changes where there is a dedicated training session. Oh, well, yeah.
It was like a bit like me not paying attention.
Yeah, I'm going to run a test after this and see if anyone's listened. So, in this case, there was no evidence that the Work Health and Safety Committee, so if you've got a business big enough where you have a dedicated Work Health and Safety team, they were not committed as part of the education program. So that is a failing in many respects. And the Commission had found that previous procedural failures involving policy breaches had not been properly managed. So some of that then brings into play the conduct of management. So management needs to be consistent. They need to be sufficiently diligent enough to make sure that there is ongoing compliance with whatever policy is that you're trying to enforce. All right. So the lessons, the obvious. Have we done enough? You can, yeah. I mean, the court's not saying you have to have the best procedure. They're not saying that every procedure is going to be the same. Sydney International Container Terminals is a big company, so the expectation on them to have proper resources dedicated to this type of change that is an important change for them, moving blood alcohol readings from 0.02 to 0.00, that they're being held to a high level of compliance, and so other businesses with less or fewer resources, less money, it may be that they don't get held to the same threshold. But what's important in this is that the Commission's saying it's not enough just to say, well, we held a toolbox meeting, they were in attendance, they signed off that they were in attendance, and that's okay. I think what the Commission's saying is we want you to do more, particularly if you're going to make the decision to terminate their employment. Like 2 years. Yeah. Yeah, 18 months, something like that. Yeah. So they goodness knows how many times they turned up with one glass of wine in there. Yeah, yeah. Or read the posters, or it might have been dealt with at five um, toolbox meetings a year. I guess what the HR team's thinking is, well, we've communicated it, we've put posters up, surely everyone should be aware, but they don't get the acknowledgement. And that's coming back to that point about acknowledgement. Maybe that's the missing part here.
Ask a bigger picture question, because I've been told that someone sounds like that's not right. So can you have a zero alcohol and zero drug policy, and that's grounds for dismissal?
Well, if it's communicated properly, yes. So, and it depends. It also depends, I think. This guy's operating a crane. It's not as if he's operating a computer. It's important, yeah. If they're driving to Dolby, Chinchilla, wherever it might be, it wouldn't be unreasonable for you to have a zero alcohol limit. Yeah, absolutely.
Yeah, someone.
Where people get where it becomes not questionable, but and not unreasonable, but is for office-based employees, particularly around we'll have beer here this afternoon. Yeah. It would be crazy for us to have a 0% alcohol policy because we have functions here where we have not an expectation that you drink, but yeah, but the opportunity to drink alcohol. Whew, a tough afternoon. So for us, it may be impractical. Where I think it does, what becomes important for most businesses, though, I think is medication that might impact your capacity to operate a vehicle, because everyone still drives to and from work. So you've got to have a policy that says you've got to be compliant with the road rules. So you can't be over obviously 0.05 or higher. But medication that might impact your capacity to operate a vehicle's a really tricky one in our space, because if we're responsible for journey claims, so driving to work and home from work. That is our domain, so we need to make sure we protect our staff in that environment. I mean, we've got staff. Have staff drive down to Brisbane, things like that.
Yeah, I know of like big consulting firms that do that.
Yeah. Sometimes it's easier just to say no. Where it becomes tricky is when senior management want to go out and have lunch, for example, with a client, and they're drinking alcohol. It's an inconsistent approach to a policy that if 0 is 0, well, 0 is 0, and that's from the top down. Yeah. Yeah, that's right.
I started having the drug and alcohol policy in place, and it written, it was already done before I got that decision implemented. But it was written around that if you're in an office-based environment, it was 0.02. If you're doing this, or this, it had to be 0. But however, if you showed up at 0.02, you could stay at work, but you just couldn't do any work. So we had to get across to our traders saying, if you're going off and having liquid lunch with ministers or whatever that would be,
yes,
you can come back to work, but we don't want you trading on the net and putting multi-million-dollar bids in.
Yes.
At a level where you are also have few, plus also they're doing it from home at night time or something, get an alert.
Yeah.
They forget to put a bid into the market, they might have a few.
Class of
So if you're on call, you need to manage that because if something goes array with the
Yes.
bid and you loses millions of dollars, there'll be an investigation.
There's a lot of
stuff's going to be.
There's a lot of trust in that environment because how do you turn up to someone's house and say, "Can you just do a random?"
Yeah, you can do it. So you've got to put that trust in. But it was one of the funny things. Like as soon as we told people in the assets in the mountains and the power stations that their Sydney office was also being had to comply with this, they go, "Oh, okay, that's okay."
Yeah.
That was the biggest win to get it over.
So long as it was consistent across everyone. Yeah.
So it's just how you worded it.
Absolutely.
How you communicate it and the ins and outs to take all that also.
Yeah.
If you had a journey claim or potential journey claim where there's already a number of conditions about what constitutes travelling home and other things, where limits 0.05 to drive on the road publicly, if you had a company policy of 0 and this person's 0.2 and then that's a journey claim, what's that do?
Well, the journey claim's the journey claim. It's a no-fault scheme. So they just get paid anyway. They might lose their job because they're non-compliant with your policy, but the journey claim's the journey claim. Yeah.
But does it make a difference how you react to those people when they're actually in the course of driving on the public road? They're still quite legal.
Oh yeah. I mean, you don't have your policies don't have to be as lenient in that case as the road rules or the rules that we're obviously all required to comply with when we drive. You can have a higher threshold or a higher benchmark for your staff. That's okay. What this is saying is that if you're going to do that, one, it's got to be consistently implemented because the management hadn't consistently implemented it, and two, your staff need to know about it. So long as you're achieving those objectives, then someone breaches it, your capacity or your permission to then discipline that person for that is I think alive. You can do that. Now, could you challenge WorkCover's acceptance of that claim? Well, because it's a physical injury, no. You're not going to. Yeah.
You could have a situation which you raised before, where we have 0 policy, so 0.9.
Yep.
But if people then, for some reason, have drinks after work and then
drive home.
Transit home, they've actually breached
policy. Yes. Yeah, absolutely.
So tell me, if someone goes to the pub on the way home,
yep,
and then drives that,
does that
the work, yeah,
Does that break the journey?
No, well, the journey is the direct travel between work and home that you would ordinarily take. If you divert from your usual to pick up the dry cleaning on the way home, that may break the journey claim. Oh my God, John! It's Friday afternoon. Well, that's not directly home though, is it?
We had cases like doing LIFO work where people are transiting through Brisbane Airport and so forth and going on to Sydney.
Yeah.
Going and the normal route is they go and sit in the Qantas lounge.
Yes. Yes.
That's their normal route.
Yeah. Absolutely.
But it was like, hey, look, as long as you're not driving.
Yeah, imagine sitting in a Qantas lounge without drinking alcohol. It's killing me.
Trips over, had a few drinks, trips over and hold that down on their footpath.
Yeah.
Did their shoulder.
Oh, right.
It's not a direct route from the check-in to the gate, is it?
Oh, I don't know. You're getting into the semantics here. All right. Well, that's all I have for you today. Any other questions before we all can go out, except you two, and have a glass of wine or a beer? Yes. Ooh.
Outside the box here, we were about, we were mentioning about the and policy change.
Yes.
I was trying to think just then, you actually haven't given us an answer of what is allowed. And then my thinking was, would you roll out a new policy to go, we've got a new policy it's replacing?
Yes.
And then I was wondering, is that now twofolding back on, they're not reading their emails?
Yes.
Say there's a meeting to be held.
Yep.
So does that mean now putting in a new policy, but they didn't read the email to say they've got to go, or to say that you need to go?
Yeah. Can you come to the meeting to?
Is that limitation of, well, how are we allowed to communicate to get that policy signed, for example?
Yes.
Because that's all I could figure was getting a new policy in place.
To answer your first question, no, I haven't answered and I can't. The second part of it is that in this case, because these crane operators are not desk workers, they have the work communicates with them to their personal email address, not to a work email address. And what the commission is saying is that if you send an email saying the policy is changing from 0.02 to 0.00, and you send that to their personal email address or you text their personal mobile phone, you can't just rely on that as being a sufficient communication to communicate that policy change. You can't, and in this circumstance, I don't think there was a communication to say, come to the meeting to talk about the change. I think it was, we have a toolbox meeting every Monday at 8 o'clock and you've got to be there because that's part of your job. So everyone turns up at the 8 o'clock meeting. It's not sufficient to say changing of policy from 0.02 to 0.00. That's not sufficient because you won't remember it when you walk out the door. There's got to be something more happening. Does that help?
It does. I'm just trying to think of how I can look for regulators as well to assist when I'm dealing with clients. And the only other thought bubble I have there is, for example, you're mentioning personal email addresses.
Yes.
Because logically, a crane operator doesn't have to have a phone to have access to a form of email.
Yep.
Would that then be if I happen to have a sniff test and went, oh, I think there's a policy change, that could be a red flag to, say, a client to go, I think maybe now's the time to go talk to someone like yourself with what you're trying to implement to ensure that you're communicating correctly and efficiently to staff. Would that be also like a stepping stone to directing in the right direction?
Be careful about relying on us to do that because our job's not to analyse the business. Then that's the role of HR, if you like. Yeah. Yeah. So so people in that space, whilst we advise them as to what the legal obligations or requirements might be, it's a matter of taking that information and going, okay, in this business, these are the type of employees or classification of employees that we're dealing with. What's the most effective way that I can communicate with them? It might be, for example, we do a performance review on every one of these staff members at the end of every financial year, or whenever it might be, 12 months, 6 months, whatever it might be. It might be that the best way for you to communicate that is at the performance review to say, here's your performance, blah, blah, blah. By the way, there is 2 important policy changes we need to notify you about. One is 0.02 to 0.00, as an example. So that's where HR really has to analyse the circumstances of that particular employer's environment, understanding better the staff that they have, and how you might communicate that to them. Yeah. There's going to be people with much more knowledge than I do on how to communicate. I'm one of those people where everyone's guffawing about why you didn't listen at the toolbox meeting. That would be me. I'd be like, what? You didn't listen? Yeah. You're not listening to me?
Like say it was us and we introduced this.
Yep.
Are we, what's the word, not entitled, but you're entitled to actually come and test you? Or does it have to be someone who's trained and qualified?
Trained.
You have to be trained.
Generally, so with drug and alcohol policy, where the fights were at the very beginning of this whole environment was there was limited consultation around the implementation of these policies, and people would kick up a stink about the fact that all of a sudden, with no reasons or explanations, all of a sudden I'm being subjected to these different invasive tests. We've come a long way since then. There's an expectation in most industries that you will undertake them. The bigger the employer with the bigger resources and more sophisticated, the expectation is that you will have a dedicated resource who's skilled and trained in making sure that they can take proper readings. Because how I might take a drug test, I wouldn't know how to administer it. I'd read the package and go, all right, put this on your tongue and give it back to me. Right, positive, you're out.
Yeah.
Whereas someone, the other people would be way more trained. Oh yeah. I mean, a lot of it's built into into contracts as well these days that you're going to be subject to them.
I'm guessing it's a good guy. You could just say have a zero drug policy.
Yes, that's generally because they're illegal. Well, no, but having said that, there are some employers where drug use is so rife in the industry that they have a tolerance for drug tests.
If someone comes to work and they're under the influence of drug,
Yes,
they've clearly broken the law.
yes.
So
Some people, if they sacked everyone that came to work with a illegal drug reading, they wouldn't have any staff.
would that be unfair dismissal if you didn't have a policy?
Well, this is if you didn't have a policy. Well, how are you meant to know? If you don't have the policy to say I'm not allowed to turn up under the
Because
influence of
illegal,
drugs.
suddenly turning up to work carrying a firearm.
Yeah.
That's not legal either. Would that not be?
All right. Oh yes.
Redundancy.
Okay.
And we reallocate others and you're an accountant and you've got a job of clean line.
Again, yeah. The skill assessment. When you do the skill assessment, you're going to go, no, that's not a suitable job.
When the employee says, I don't want that job you're offering me.
Yes.
Redundancy then stand.
Yes. It would be hard to run an argument to say I was offered redeployment, I rejected it, but it's still unfair. That would be a very hard argument to run.
This job longer.
But I have, yeah. Well, no, you just make their position redundant at that point. Yeah. If you win the lotto and they say, oh, well, I'm just going to resign, and you don't have to pay severance pay, then maybe that's okay. But that would depend on how they respond to or react to your proposition. Well, you can't go redundancy or reallocation. You've got to go reallocation. This is we can redeploy you into this role. What do you want to accept that or not? Because if you don't, then the next consideration is redundancy. Yep. So you got to get the process right. Because if you go redundancy then redeployment's too late. All right. No, lovely. Thank you.